Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we have picked up a couple of important articles from the Hindu which are very significant from your GS paper 1, paper 2 and GS paper 3 perspective. Let's get started and look into the first article. The first article is speaking about POCSO. Let us try and understand what is the intent of this article. When we speak about POCSO, it happens to be one of the major laws in the country in order to prevent sexual offences against the minors. First important factor that we have to understand is who is a minor, who is a child. Any person who is less than 18 years of age happens to be a child. When it comes to the POCSO Act, there are two important parts that we have to look into. One, POCSO happens to be a gender neutral law and there is no time limit to report a POCSO case. What do we understand by a gender neutral law? When we speak about offences like rape, is it a gender neutral law? No, it is not. It means that only a woman can go through this heinous offence of rape. So when it comes to rape, which is booked under section 376 of the IPC, it can only be committed by a man against a woman. So the victim in all cases will only be a woman. So is it gender neutral in nature? No. But when it comes to POCSO, it is gender neutral in nature, which means a boy can also be a victim, a girl can also be a victim. But when it comes to rape cases, it is only a woman who can be a victim. But when it comes to POCSO cases, a boy can also be a victim, a girl can also be a victim, which means to say any individual who is less than 18 years of age, it can be a boy or a girl who is less than 18 years of age can become a victim in this particular case. So the perpetrator can be a man as well as a woman. There have been ample number of cases as well where women have also put on sexual offences against a boy and women have also been held culpable in these POCSO cases. So the first important factor is that this happens to be a gender neutral law where the victim can be a boy or a girl, and when it comes to the perpetrator, it can be a man or a woman. When it comes to rape laws, the victim is always a woman. When it comes to the perpetrator, it is always a man. That happens to be the first point. The second point is with respect to the time limit. What do we understand by time limit? Let's say for example, there is a POCSO case or there is a sexual offense or a sexual assault on a child. The child at that moment may not know that a sexual assault is being conducted against a child. But once the child reaches an age of maturity, the child may know that so and so incident happened to the child, and even at that particular moment, the child would be able to tell to the world and to the police officers as well as the state that so and so incident happened to the child. So there is no time limit for the prosecution of the POCSO cases. Let's say an incident had happened 5 years ago or 10 years ago, and if it is being reported today or tomorrow, despite that act occurring 5 to 10 years ago, even in that case, what we will have is the culpability to this entire issue. The person whosoever is the aggressor, the perpetrator, can still be thrown behind bars and can still be prosecuted as well. These are the two major points when it comes to POCSO. Now, when it comes to POCSO, what is another major problem with respect to POCSO? That is what is called as the statutory rape. What is the statutory rape? Let me explain this with the help of an example. Let's say for example, there is a boy who is less than 18 years of age, or there is a girl who is less than 18 years of age, or let's assume for a moment there is a girl who is less than 18 years of age, but there is a boy who is less than 21 years of age. What is the legal age to get married? For a girl, it is 18 years of age. For a man, it is 21 years of age. What if there is a person who engages in a physical intimate relationship and is less than 18 years of age? Let's say for example, there is a man who is less than 18 years of age and has engaged in a physical intimate relationship with another girl who is less than 18 years of age. What is the point here? Both of them are less than 18 years of age. In that particular case, when does the law permit a person to engage in a physical intimate relationship? It is only after 18 years of age. But if a boy enters into a physical intimate relationship with a girl, despite the girl giving the permission and the consent, even if he is less than 18 years of age, this person can be assumed as a statutory rape. What happens in rape? In rape, there is no consent that is given by a girl to have a physical intimate relationship. So the consent is not given in this case, but in statutory rape, consent is given by the girl, but the law does not permit for a girl or a boy to engage in a physical intimate relationship, which is called as statutory rape. So what is statutory rape? Anyone who is less than 18 years of age or a girl who is less than 18 years of age has given consent to the boy, and then the boy has entered into a physical intimate relationship. So this means the girl does not even have the permission to give the consent, and if a boy engages in a physical relationship with the girl despite giving the consent, that is what is called as statutory rape. What is the concern here? What happens is, at this particular moment, let's say between the age group of 16 to 18, a boy and a girl will undergo a lot of physical transformation. There is a transition that is taking place from teenagership to adultship. In few specific cases, there might be few boys and girls who would want to explore their bodies. At that particular moment, they might engage in a physical intimate relationship. So a girl would have given consent to the boy. So they might have entered into a physical intimate relationship. At that particular moment, the boy who is less than 18 years of age can be thrown behind bars. Why? Because he has entered into a statutory rape. This is barred by law. Despite given consent by the girl, he should not be entering into a physical intimate relationship. But now that he has entered into a physical intimate relationship, there are examples as well where the girl has also become pregnant, where the girl has given consent, but this is not taken lightly by the parents. They've also filed charges against this boy who has entered into a physical intimate relationship, and as a result, rape charges are filed on this boy for entering into a physical intimate relationship, and ultimately he is thrown behind bars by the police officers as well as investigating officers. That is when they appear before the court, and the court in this case has also looked into the larger premise. What has the court said? In this case, there is a romantic relationship between a boy and a girl. The girl has given consent to it. It is not a forced consent, it is a consent on mutual respect as well as mutual obligation. So in that particular backdrop, since the girl has given consent, why not come up with what is called as the Romeo and Juliet laws? So the Madras High Court has spoken about it. We have couple of other high courts who have spoken about it, and we also have the Supreme Court of India, which has also asked the central government why not revisit this particular provision, where in case there is a girl and a boy who are in a romantic relationship, let's say for example girl and a boy are less than 18 years of age, or the girl is less than 18 years of age, but the difference between the girl's age and the boy's age is not more than 3 to 5 years of age. In the consider this as not a rape, so that this person is not thrown behind bars and his entire career could also be at stake as well. So what is the Madras High Court speaking? What is the Supreme Court saying? Let's consider an alternative where this will not be considered as rape if they have consent, and if the age gap between a boy and a girl is only between 3 to 5 years of age. So the Romeo and Juliet laws provide some degree of protection to offenders of statutory rape laws where the minor has consented to the sexual intercourse and where the age difference between the minor and the alleged offender is very less. The law is applicable in many countries. Prior to this, rape charges used to get imposed in teen sex only if the boy was an adult. However, since 2007, many countries have adopted Romeo and Juliet law, which protects the boy's arrest if his age was not more than 4 years from the age of the teenage girl. So this means, let's give an exception in the POCSO Act or in the general laws, that if they have consented to it. It happens to be a romantic relationship. Let's give them an exception. Let's add a proviso, and ultimately these people are not booked under the clauses of rape, is what is being discussed by the Madras High Court and by the Supreme Court. Then we have the Law Commission, which enters into this particular picture. So a recommendation has been made. So the Law Commission was also asked a question, look into this entire premise that should we have the Romeo and Juliet laws. So the Law Commission now has come up with its verdict, and it has now said that such Romeo and Juliet laws should not be present as a law. So it should not be present as a law, but instead a certain amount of discretion should be given to the courts. The court should decide on its own whether this happens to be a Romeo Juliet case or not. If it is in the law, there could be a premise where there could be people who take advantage of this entire law. So instead of taking up this entire premise into a law, why not give discretion to the courts? Let the court investigate, and during this particular premise, let the boy be given the bail immediately. So the minute there is a charge of rape that the boy is accused of, immediately bail will have to be granted to that particular person, and while the investigation is on, let the court decide after the entire trial process whether it is a Romeo and Juliet relationship or it is a forced consent, or a man has forced upon a girl in this particular premise. So instead of coming up with a law for the statutory rape, why not have it in the form of discretion given to the courts? Let the court conduct the entire trial, ultimately come to a conclusion, and meanwhile this person can also be given the bail so that he is not thrown behind the bus. So his career is not at stake. So the Law Commission in this particular case has clearly clarified, let's not come up with a law, but instead let's organize and give more powers to the Supreme Court as well as to the High Court as well as to the court. Let them decide and ultimately conclude whether it is a romantic relationship or not. It is this that we have to understand with respect to this article. Now let's look into the next article. This article here is speaking about women reservation. The reservation is with respect to the police officers, that is the women police officers. Vacancies are created, and about 33% whenever there is a vacancy, let's give about 33% of the vacancies that is permitted in the police department to the women. So this author primarily goes on to say that we recently had the introduction of the women reservation bill and a constitutional amendment, that is Constitution 128th Amendment Bill of 2023 was also passed by the Parliament. Both the houses, that is the Lok Sabha as well as the Rajya Sabha, have given permission to it, and this will also get the assent of the President of India, and once it gets the assent, it will ultimately become a constitutional mandate where about 1/3 of the seats, that is about 33% of the seats, will have to be reserved for the women, where in the Lok Sabha, in the Rajya Sabha as well as in the Delhi State Assembly, and this will be reserved for about 15 next years. So after this is passed, whenever it is being implemented for the next 15 years, this reservation is provided so that the women would be able to empower themselves. So the point that needs to be taken into picture is that there will be a constitutional amendment, and this amendment will basically ensure that in the Lok Sabha, that is in the MPs, that is in the Lok Sabha and in the state assemblies, wherever they are contesting, 33% will be reserved for them. So this will help ensure that the women are empowered and there is more participation of the women in the policy making. However, there is one small catch when it comes to the reservation for the women. What is that? This reservation has already provided 1/3 reservation for the SC/ST community. So whosoever is the women who is coming from the SC/ST community, out of 100 seats, let's say for example, about 33% of the seats, that is 1/3, will be provided for the reservation of the SC/ST. The rest is not provided for the OBC. This is what the opposition was speaking about. Another major point is with respect to the implementation. What happens with respect to the implementation? This is going to come into implementation only from the year 2029, that too provided that the census 2021 is not pending and is taken up as well. So if this can be changed and tweaked and can be implemented in the subsequent elections, that will also be better, says the author. These are one part of it. So the author says when women reservation can be provided in Lok Sabha, in the Rajya Sabha, in legislative assemblies as well, in the Lok Sabha and in the legislative assemblies, why not introduce the same kind of reservation even in the police department? Why does the author say so? That is where we have to look into the statistics. When it comes to the police department of late, the data on police organization, a publication by the Bureau of Police Research and Development, shows that while the total available strength of the state police officers increased by about 7.48% in the last 5 years, that is from about 9.26 lakhs as on January 2017 to about 20.7 lakh on 21 against a sanction strength of 24.64 lakh and 26.31 respectively. The representation of the women in the state police increased from 1,40,000 to just 2,17,000. So what we are witnessing is there is not much representation for the women when it comes to the state police stations. So when it comes to the police, it is under the control of the state government. Why? Because police and public order is in the 7th schedule under the state list, and as a result what we actually witness is less number of women when it comes to the stage. So there are less number of women who are present in the police departments, and this has to change, says the author. Now if we have to look into how the states have accommodated, there are a couple of states who have provided some reservation, there are states who do not have the reservation. So what we need to have is one holistic structure, says the author. According to the details published by the BPRND, we have states like Kerala, Mizoram and Goa who do not have a policy of reservation for the women in the state police. So these states do not have any kind of reservation. Now if we look into other states, let's say for example, women's representation in states varies from 6% to 11%. Bihar provides for 35% of the reservation for the women and 3% for the backward caste women, but the actual number of women in force is about 17.4%. Chandigarh has a maximum percentage of women, about 22% in the police force, while Jammu and Kashmir has a minimum about 3.3%. Himachal Pradesh has not notified reservation for the women, but 20% vacancies of constables are filled up by women. Though the Ministry of Home Affairs has repeatedly asked states to increase the representation of women in police to 33%, the actual availability remains low, says this article. So when we look at the states and their data, what we have is decreased numbers. And when we look at the attrition rate, what is this attrition rate? If there are certain number of people who are entering, there are also people who are leaving the organization as well as the police department. So attrition rate is the rate at which people leave an organization. So as and when there are people who are also vacating, leaving that particular job, we need to accommodate them as well, assuming that the attrition rate in the police force is about 2.5% to 3%, and the annual sanction rate for the new post is about 1.5 to 2%. Recruitment is done only against 4 to 5% of the total post. So out of the entire 100%, only 4 to 5% of the votes, 4 to 5% of the women are getting their postings. Thus, going by the past, it can be that in less than 20 years, the women's representation from 20 to 30% in the entire police force. So this is where the author says that the representation of the women is comparatively less. So what we have to do is increase the number of women who are present in the police forces. Why? That is because the author brings into picture a couple of arguments. What are these arguments? One, the author goes on to say that when it comes to criminal law and the criminal procedure, they are present in the concurrent list. Since they are present in the concurrent list, state governments would be able to make the laws, central government would be able to make the laws, and central government has made a couple of laws when it comes to criminal law and the criminal procedure, where they have to release certain reports and statements every now and then. And as a result, these reports and statements will require the presence of the women, and these women are not present in the state departments. And when it comes to, let's say there is a woman dacoit, or there is a woman who's involved in robbery, theft, so on and so forth, Who are the persons who can investigate another woman's role? It is only the women. It is the women who would be able to make the arrest. It is the women who would be able to search another woman as well. When you do not have the numbers to actually go about and check and make an arrest, how are we going to deliver the justice system to the country? How are we going to ensure the law and order in the country? How are we going to ensure the public order in the country? Even if it is frisking that has to be done, it has to be a woman who has to be employed, and it is the woman who has to take care of this entire custody. It is the women who has to protect these women who are present in the prisons as well. So if women are not employed in the police stations and in the prisons, we do not have the enough numbers, and as a result what we require is women officers. So on one side we have the periodic reports as well as statements that are being made, and these statements will have to be recorded by the women. There has to be arrest that has to take place. It requires the presence of the women police officers. So all in all, what we require is more women police officers, says the author. 10% of the total crime defined under the Indian Penal Code was committed against the women, and about 5.3% of the total arrested persons in 2021 were also women. So we do not have sufficient number of people who would be also able to make the arrest. Since we have insufficient police officers, this has to be taken into picture. Then we have law and order issues, day-to-day daily activities as well. And when we look at POCSO Act has also given responsibilities to the women. Let's say for example, there is a child who has gone through this grievous issue of POCSO. So it is a woman who would be able to comfort the victim. There are additional responsibilities that are given to the women when it comes to POCSO cases, and women can also handle any kind of assignment in a police institution. So why not come up and reserve 33% for the reservation for the police officers is another area that is brought into picture. While we have reservation for the parliament, that is for the Lok Sabha and the state assemblies, why not introduce the same when it comes to the state level police reforms? The author goes on to say what are the major impediments right now. The major impediments and the measures that have been taken by the government is: 1. The major impediment is police being a state subject in the 7th schedule. Only states should be able to implement it. So states on their own would start implementing such things, then there will be a major transformation, says the author. MHA began providing financial incentives from 2018 and 19 by reserving 10% in the first year and 20% of total modernization funds thereafter to the states. Ministry of Home Affairs has also provided special grant to encourage states to establish a women desk in every police station. MHA has a special provision in the modernization plan to build separate toilets for women staff and ensure creche facilities for the children. These are some of the measures that have already been taken. Despite these measures, we have to upkeep and also increase their presence in the law and order. So what is that we have to do? We have to create conducive environment and provide basic infrastructure. As we just discussed, some of the basic infrastructure would be about creche services. It is about building toilets, separate toilets for them, restrooms for them. And what the government can also think of is the Uniform Police Act. Yes, when it comes to police law and order, it is under the domain of the state governments, but criminal law and criminal procedure is also coming under the concurrent list as well. So why not the central government create one uniform law and ask the states to follow certain laws uniformly across the entire country, and rest of the other part which falls into the domain of the state list, they can create their own set of rules and regulations for the same, come up with a uniform law, and for the rest of these give the discretion to the states so that they can come up with their own rule book. And we need to have a recruitment board, and the recruitment board should be able to recruit the women for these 33% of the vacancies, and we have to create a special drive. If we are able to do so and create 33% reservation for the women, as much as the reservation that we are all happy about in the parliament and in the state legislative assemblies, we will also be happy about the police force as well as the law and order, says the author. It is this that we have to understand with respect to this article. Now let's look into the next article. This article here is important from your GS3 perspective. This is important from your economy paper. Let us try and understand what is this article all about. This article is primarily speaking about the dispute resolution. What is a dispute resolution? A dispute resolution basically means that there are issues that exist between two countries. Let's say for example, there are these WTO rules that are already in existence. If there are these WTO rules that are already in existence, if there are parties, if there are countries which are not happy with certain rules and it requires an interpretation of these rules, or there is a particular service that is being provided by India or by United States of America, or a certain amount of subsidy is being provided by India and this is not taken up easily by the developed countries, where do we resolve all these issues and concerns? To address these issues and concerns, what we have is called as a dispute settlement mechanism. So the recently concluded G20 declaration, among its many commitments, reiterated the need to pursue reform of the World Trade Organization to improve all its functions and conduct proactive discussions to ensure a fully and a well-functioning dispute settlement system. So what are we speaking about? We are speaking about the dispute settlement system. When we speak about the dispute settlement system, do understand that when it comes to dispute settlement system, there are two parts that are there. One is with respect to the government, the other is with respect to the private sector. Why do countries and even parties enter into a dialogue as well as interstate trade? That is because all that they want is profits, all that they want is stability, all that they want is the predictability. In order to ensure this predictability, stability and also profits, what you require is the rules and regulations. What if countries start operating in the whims and fancies? Let's say for example, I from India, I have provided one of the services to, let's say, United States of America, or United States of America has taken some goods from India to one of their companies in United States of America. What should be the ideal module? The ideal module should be that I have given a service, I have exported one of the goods, so immediately I have to receive payments within a specific period of time as per the conditions that are laid in the agreement. What if United States of America's companies or the government is not paying a certain amount of money? In that particular case, where do I go? There is no stability in this particular case. There is no predictability in this particular case. I do not know whether I'll be receiving the money or not. So why would I want to do any of the businesses with any of these firms in United States of America? I would not want to do it. So in order to ensure that there is communication, in order to ensure that there are exports from one countries to another, what we require is stability, what we require is predictability, what we require is a rules-based order. So such rules-based order is created in this dispute settlement system. So if there is a dispute, if there is an issue, if there is a problem between one party and another, so where do we approach? We approach the World Trade Organization's dispute settlement system. So I have a problem, he has a problem, let's sort it out amicably. If that cannot be done, both of us sit together on a table, we face each other, we enter into a mode of arbitration, we seek out issues, and if we are not able to conclude it on an amicable basis, we have the dispute settlement system, which will ultimately help us ensure overcome these disputes, whether it is services, whether it is goods, whatsoever it is. I have made an export or I have received an import. In this particular backdrop, I would be able to settle these differences in the dispute settlement mechanism. So when we look into the dispute settlement mechanism of the World Trade Organization, it has a two-tier structure. What do we mean by two-tier structure? It will have two structures. One is what is called as a panel, the other is what is called as an appellate body structure. So the minute I have a problem, I take this problem to a panel. So there will be World Trade Organization. The World Trade Organization will have two bodies. One will be called as a panel, the other will be called as an appellate body. So immediately there is an issue, I go to this particular panel, which happens to be the first tier. So I say that this and this is my problem. I had given so and so services, this person is not paying me the money, I want the money with so and so interest to be given, and that is what is called as the consent award. So when it comes to the laws in the country, you have to understand there are two types of awards. What are these two types of awards? One is called as the general award The other is what is called as the consent award. What is this consent award? Consent award generally appears in the arbitration where both the parties accept to a mutually accepted terms and conditions. Let's say for example there is some violation, so according to the agreement that they already have, we will go to the arbitration, we will appoint an arbitrator, the arbitrator will award an award, and during this entire process they will enter into a consensus. So for this particular damage that I have created, I will be giving you a damage for so and so. So the damage would be about 1 lakh, it will be 2 lakh at the rate of about 5%, so on and so forth. So we enter into a consensual mode, and that consensual mode where we amicably settle the differences is what is called as the consent award. So remember, in arbitration we have something called as the consent award, and this consent award is basically decided on their own, and ultimately the same is taken into the picture. So when it comes to an issue, we can settle the issue amicably, and we can also seek for the consent award, which basically means the parties have accepted to it, or this can go to the panel. The panel will have people from different countries, and they will also have experts of that particular domain. They will approach this particular panel, and the panel will ultimately give a conclusion to it. And this conclusion, if it is not taken up by both the parties, if both the parties accept, there is no issue whatsoever. But what if one of the parties does not accept, or both the parties do not like this particular verdict? So where do they go? They go to this appellate body structure. So the first tier happens to be a panel. If it is not taken up by one of the parties or both the parties, they ultimately go to the appellate body structure. It is this appellate body structure which will decide what should be the final proceedings, and it is this appellate body which also has the viewpoint of this entire section. They know what the panel has discussed, they will also know what is that these parties are looking for, and ultimately a decision will be made by this appellate body. But what is the concern right now? This appellate body structure has become dysfunctional since 2019, and United States of America has blocked the appointment of the appellate body members, and that has become the major issue. And what is the importance of this appellate body when it comes to such organizations, or for example any dispute mechanisms? An appellate body would be able to judge in detail at a greater level than a panel body. So these grievances can be addressed by the appellate body, but we do not have the existence of this appellate body right now because it has become dysfunctional. Members are not appointed, and that has become the major impediment in the present situation. If we have to juxtapose and compare what have been the rulings of the dispute settlement mechanism, it has issued over 497 rulings since its establishment in 1995. But when you consider the International Court of Justice, it has dealt with only 190 cases since 1947. So the kind of subject matters, the kind of matters that come before the dispute settlement mechanism, and the kind of issues they have also dealt is far in excess in comparison to the International Court of Justice. So you juxtapose and see, they have given more justice, they have delivered more international commitments, they have given more judgments and passed the decrees in all these cases in comparison to the International Court of Justice. So this means that this appellate body and the panel are doing some exceptional job, and this dysfunctionality should be completely removed is one such argument. Apart from that, we also have another argument, that is in terms of the investor state dispute settlement. What is this investor state dispute settlement? This investor state dispute settlement is part of the bilateral investment treaties. What are these bilateral investment treaties? Let's say for example, India and United Kingdom is entering into an agreement. India says that we will be providing you so and so service, and we will be providing you so and so goods, and United Kingdom will also say that we will have our company, that is a company based out of United Kingdom, come and it will make an investment in India. So the minute the investment is made, they have made a large amount of investment. Let's say for example, Indian investors have gone to United Kingdom, they have made a large scale investment, foreign direct investment has been made, and when it is made in United Kingdom, all of a sudden they ensure that certain agreemental clauses are not taken into picture, and they also start violating as well. So we have a bilateral investment treaty, an agreement which both the countries have accepted, and they will also say that they will implement it, but all of a sudden these terms and conditions which are prescribed in the agreement is not being implemented by the countries. In that particular case, if they have issues when a bilateral investment treaty is already ongoing, if something arrives out of it, the other mechanism that they also have is called as the investor state dispute settlement. So what is it? It is a mechanism of a free trade agreement or investment treaty that provides foreign investors with the right to access international tribunal to resolve investment disputes. We have the Vodafone issue, we also have Kane issue. All these cases went up to the Singapore International Arbitration as part of the investor state dispute settlement. The Vodafone issue is Hutch issue, or the Vodafone issue is based on this investor state dispute settlement. So a foreign investor in India or an Indian investing overseas can use ISDS to seek compensation for certain breaches of a country's investment obligations. What are these obligation setting parameters? On expropriation of a foreign investor's property. I have made an investment, I have invested a lot of money on the infrastructure. Now all of a sudden, if a country and its administrative mechanism asked me to withdraw from that particular property where I have made an investment, this is a violation of ISDS. Then there has to be non-discrimination and minimum standards of treatment, such as protection against denial of justice. So if a company is making an investment, this company and another company should be treated equally. Just because there is one company of Indian origin, just because there is another company of UK origin, does not mean that we treat discrimination. There is discrimination against one party and another. A commitment to ensure foreign investors will be able to move against capital relating to their investment freely, subject to appropriate safeguards. So these will also have to have safeguards as well. So an ISDL tribunal cannot overturn domestic laws and regulations, but instead the tribunal is limited to determining breach of certain investment obligations. So they had an agreement in place, they had a contract in place, these contracts have been violated, strict yourself only to that, and you cannot interpret the domestic laws whatsoever is present. So the investor state dispute settlement will only look at what are the contractual violations. So this happens to be an additional mechanism. So the author in this particular case goes on to say that till January 1, 2023, 1257 ISDS cases have been initiated. India has also had a checkered history with ISDS, with 5 adverse awards, 4 in favor, and several pending claims as well. So an alternative to the dispute settlement mechanism of the World Trade Organization happens to be investor state dispute settlement, says the author. This is where the author goes on to say, if this investor state dispute mechanism or the appellant body does not exist, what are the issues? So what the author says is that we have the panel, we also have the appellate tribunal, and when it comes to this ISDS, what it requires is an additional layer of investigation in the form of appellate tribunals. So it says that appellate tribunals are very essential. Why? If there are no tribunals, that is appellate tribunal, there can be ad hoc or one-off arbitration tribunals. There will be just one layer. This one layer, whenever it is looking into this particular issue, this one layer or the panel or this one single layer of dispute resolution mechanism for the same terms and conditions that exist. Let's say, for example, there are terms and conditions that exist between the companies as well as between the countries. If the terms and conditions that exist, there are these panels that have given diverging viewpoints. They have said in one of the cases that this is the verdict. In another similar set of terms and conditions, they have given opposite viewpoints as well. So they've drawn opposite conclusions and they've given diverging interpretations for the similar kind of terms and conditions. Had we had the appellate body, they would have looked into this entire premise, reviewed it time after time, and ultimately would have given a concurrent viewpoint. Because we do not have so, absence of appellate review mechanism has meant inconsistent and incoherent decisions and legal reasoning that dot the landscape of the international investment law. So there will be there will be instability, there will be no predictability, and countries would not want to engage in this export business. So what is the significance of these appellants? It will rectify errors of law and harmonize the diverging interpretations. It will infuse predictability and certainty into the ICDS system, and the appellate mechanism will also be better than existing mechanisms such as annual proceedings, which only apply to the arbitrations administered by the International Center for Settlement of Investment Disputes. And do note, when it comes to this International Center for Settlement of Investment Disputes, India is not a member of this particular center. So the author goes on to say that what we require is these ISDS appellate systems, which currently does not exist. Added to it, there are also discussions on creating appellate review mechanisms, which are ongoing in the United Nations Commission on International Trade Law and UNCITRAL's Working Group 3. They are deliberating about coming up with this appellate review mechanism, but what is the form of it, what should be the structure, who should be the people, how they should conduct this activity. A deliberation is going on. Once they have it, even if it comes into picture, it is going to be a very good appellate tribunal, says the author. India presumably also supports this system of appellate review in the ICDS because Article 29 of the Indian model of the BIT talks of it. Given India's concerns about inconsistency and incoherence in the ISDS system, supporting the creation of the appellate review mechanism will be of India's interest. So even if these bodies are coming up with these appellate tribunals, India will support it because the most of these bilateral investment treaties that India has signed has also supported this very clause of appellate review mechanism. So India already supports it. So what we require is the appellate tribunals whose presence have to be continued, and whatsoever is United States of America doing, the dysfunctionality which led to this particular appellate tribunal not working efficiently, this has to be addressed as soon as possible, is what is this article all about. Now let's look into the next article. This article here is speaking about measures that have been taken by the Delhi government to focus on air pollution. So what is this plan all about? They have now said that in order to fight the pollution, they have come up with a 15-point winter action plan. The plan will basically include controlling stubble burning, vehicular population, open burning, dust pollution. So what I want you to do is, it is a simple article. Just go through these articles. Then there is use of biodecomposer, then there is PUSA decomposer which is used, how to control, then they are making use of these industries which cannot operate, and they have also said that particulate matter will have to be within a prescribed standard. Then there is a threshold that is set, it will be less than that as well, and odd and even formula which they had originally tried, will it be implemented or not. We will also have is the anti-smog guns. These anti-smog guns was recently discovered in a daily current affairs discussion as well. These are some that will be implemented. So what will be implemented? Just go through this article. It's nothing technical as per se. So if you go through it, you will understand. So these are measures taken by the Delhi government to find air pollution. The next article is important from your preliminary examination, and it speaks about SASTRA Ramanujan Prize. What is the SASTRA Ramanujan Prize? This is awarded for this year to Ruixiang Zhang of the University of California, Berkeley. This is an annual award, so it is given every year, and $10,000 prize is given for the contribution to these individuals who have been able to make contributions in the area of mathematics influenced by Indian mathematics great Ramanujan. So it is awarded every year to a young mathematician judged to have done outstanding work in Ramanujan's field of interest. The age limit for the prize has been set at 32. So any individual who is less than 32 years of age, who has been able to make major contributions to the field of mathematics, they would be awarded this award. So this is important from the preliminary examination point of view. So Mr. Zhang received his BS degree in mathematics from Peking University in 2012, PhD in mathematics at Princeton University, and he has made a major contributions. His fundamental work spans analytic numbers, combinometrics, Euclidean harmonic analysis, geometry. Building on his doctoral thesis, he and Sharma proved a generalization of the main conjecture in the Wingrow's mean value theorem, which is concerned with sums of numbers raised to a certain power. All these are very, very important and can be probably asked in your preliminary examination. It is this that we have to understand with respect to this article. So in case you're liking these articles, please do like, subscribe to our YouTube channel, and also please tell your other fellow aspirants as well. So this is it for today. Thank you for watching. All the best.